Namaste, Namaskar, Assalamu alaikum and Vanakkam. Friends, is my audio clear? Hello. Hello everyone. Friends, is my audio clear? Hello everyone. Hello. Hello. Friends, is my audio clear? Yes. Okay. Friends, as part of the live lecture series on India's largest education platform, Unacademy, today we will be discussing one of the important concepts under the code of suits by government and the suits against the government. Friends, sections 79 to 82 and order 27 of CPC concept of suits by government. Now friends, if you want to compete with thousands of get Unacademy Judiciary subscription today, friends, you can crack the judiciary services examinations by subscribing Unacademy Judiciary plus subscription today, and you can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer. Okay. Friends, then the suits by suits by or against government, suits by or against government his peaceful possession and enjoyment over Mr. A's property. Now this is a relief, friends. A can immediately knock the doors of the honorable court for suitable relief. He can get an ad interim injunction also, even in the options of Mr. B. Now let us see the same illustration with a few changes, friends. Now Mr. A is the owner of this property. Mr. B is trying to encroach his property. Therefore, A has instituted a suit against Mr. B for the relief of permanent injunction. Now, he has immediately approached the court and has instituted a suit. Immediately, the suit is numbered. Now, adjacent to A's property, here there is a government property. This land belongs to government. Okay, this land belongs to the government. Now the government has occupied this land, this portion of land from Mr. A. Now can Mr. A immediately institute a suit against the government? No, absolutely. It is not permissible in the court of law to institute a suit immediately against the government without serving a statutory notice to the government. Therefore, friends, we need to understand the importance of suits against the government and suits by the government. Who have to institute a suit in case if the right of the government has been infringed by the act of any institution or act of any individual. Now friends, therefore in this class we will be discussing suits by the government and the suits against the government. Okay, now friends, let us see now Friends, always keep a bare act with you. Okay. Let us see section 79 of CPC. Section 79 of CPC. Okay. Just go through section 79. Just go through the bare act. Section 79 speaks about suits by or against government. The title itself is suits by or against government. Part 4 of CPC is relating to suits in particular cases, especially under this one, suits by or against the government or public officers in their official capacity are enumerated from section 79 to 82, friends. Now let us see the ingredients of section 79 of CPC. Okay, section 79 of CPC. Section 79 of CPC. Now the title is, friends, the title is that suits by or against government. This is the title of section 79 of CPC, friends. Now let us see the ingredients. In a suit by or against the government, the authority to be named as plaintiff or defendant, as the case may be, shall be, in case of the suits by or against the central government, the Union of India, and in the case of suits by or against the state government, the state. Therefore, friends, according to section 79, all the suits come under this category. Like if a suit has been filed by the government and if a suit is filed against the government, in both the cases, if the government wants to institute a suit, if the state government wants to institute a suit, first, if the central government wants to institute a suit, whether the central government may be the plaintiff or defendant, if it wants to institute a suit, or any suit has been instituted against the central government, then directly central government, that name cannot be used as a plaintiff or defendant. Friends, generally, if we see the cause title of any case, okay, the title is in the court of the honorable junior civil judges court, junior civil judge, okay, comma ABC. Here, friends, ABC is the name of the station. Okay, it is a place of this court. Now, OS number 123 of 2021. Okay, between now, if the central government wants to institute a suit, okay, if the central government wants to become a plaintiff, if it wants to institute any suit against an individual or against the other state government or against any institution or society, etc. Now, the central government, this name cannot be used as plaintiff and defendant. Okay. Now, in the place of the central government, if the central government wants to institute any suit, or if any person wants to institute a suit against the government, if a suit is filed by the government, central government, if a suit is filed against the government, then The word central government cannot be used as a party to the suit. Here, in the place of central government, we need to use Union of India, the Union of India, the Union of India. This word has to be used, the Union of India. Okay. The Union of India, this word has to be used. If either the government wants to institute any suit, or if any suit has been instituted against the government, then if the central government has been named as one of the parties to the proceedings, then central government, that word cannot be used. But in the place of the central government, the word the Union of India should be used. This is the rule, friends. This is the rule. In between Union of India, plaintiff, and XYZ is the defendant. Now, in this way, the cause title has to be fixed, friends. In this way, the cause title has to be fixed. This is about the central government. Okay, either in the place of the plaintiff, if the suit filed by the government, or in the place of the defendant, if the suit is filed against the government, in the place of the central government, the word the Union of India has to be used. Similarly, in case if the state government wants to institute a suit against some other party, or if any party wants to institute a suit against the state government, then the word the state shall be used. In the place of state government, the word state shall be used. This shall be used. It is very clearly stated under section 79 of CPC. According to section 79 of CPC, okay, in a suit by or against the government, the authority to be named as the government should be named as Union of India in case of the central government, the state in case of state government. It is very clearly stated under section 79 of CPC, friends. Now, let us see section 80. 80 is the most important section. 80 is the most important section. Section 80, it speaks about statutory notice. Statutory notice, friends. Section 80 speaks that, okay, if any suit has been instituted by any party against either the state government or the central government, a statutory notice has to be served before institution of such suit. It is very clearly stated. Just go through the Where Act, friends, wherein you can find that save as otherwise provided in subsection 2. Therefore, subsection 2 under section 80 of CPC is an exception for section 80. Okay. Now let us see this one. No suit shall be instituted. No suit shall be instituted against the government, including the government of state of Jammu and Kashmir. No suit shall be filed against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity. Therefore, no suit shall be filed against the government or against a public officer in his official capacity until the expiry of 2 months next after notice in writing has been delivered or left at the office of. Therefore, it is very clear, friends. It is very clear. Therefore, according to section 80 subsection 1, okay, if any party wants to institute a suit, if a party wants to institute a suit against the government he cannot automatically file that suit against the government without serving a statutory notice under section 80 subsection 1. Okay, if a party wants to institute a suit against the government, first or institute a suit against the government or against a public officer, okay, against a public officer in his official capacity. Friends, these are the important words. Public officer in his official capacity. Even though a person is a public officer, if he make any defamatory remarks against a party, not on his official capacity, through his private acts, if he make any defamatory statement, if he done any wrong, not in his official capacity, if he did any wrong for the wrongs did by him, the party can institute a suit. Therefore, section 80 subsection 1 cannot be applicable to those cases, friends. But if a party wants to institute a suit against the government or a public officer in his official capacity against the government or the public officer in his official capacity, then a 2 months prior notice under section 80 subsection 1 of CPC is mandatory. It is mandatory, friends. Therefore, we have seen this one. We have seen this illustration in the first slide itself. Here, Mr. A is the owner of this land. Now his land has been occupied by Mr. B. Immediately he can institute a suit against Mr. B for the relief of ad interim injunction. Now, if it is the government land, if the government itself making serious efforts to occupy the private party's land, what is the relief? What is the fate of the private party? He cannot institute directly a suit against the government. He cannot institute a suit without serving a prior notice under section 80 subsection 1 of CPC. Therefore, it is the importance of section 80, friends. Therefore, 2 months prior notice under section 80 subsection 1 CPC. It is a statutory provision, friend. Therefore, 2 months prior notice under section 80 subsection 1 CPC is mandatory. Statutory notice under section 80 subsection 1 CPC is mandatory, friends. This is the first essential condition if any party wants to institute a suit against the government or a public officer in his official capacity. The next essential element is that after expiry of 3 months, now friends, after expiry of the 3 months, he can file a suit. Now, we need to remember one important thing, that 2 months prior notice under sections 80 subsection 1 is compulsory according to section 80 subsection 1, friends. Now, to whom such notice has to be given? Directly to the Union of India, directly to the state government, that is a particular state. To whom it has to be addressed? To whom the notice under subsection 1 CPC has to be addressed? It is a big question mark. It is a big question mark, friends. But here, if we see section 80 subsection 1 of CPC, it is very clearly stated that in case a suit is against the central government, okay, in case of a suit against central government, to whom this notice has to be addressed. In case in case the suit is against central government, especially railway department. In case of other departments, here these two are related to this one, friends. Therefore, I would like to distinguish this one very elaborately. Okay. Central government, railways, otherwise than railways. Okay. Or other than railways. Okay, it is very clear, friends. It is very clear. Other than railways. In case of state government, again, to whom statutory notice under section 80 subsection 1 of CPC has to be served. Then, in case of Jammu and Kashmir, state of the government of Jammu and Kashmir, to whom it has to be addressed. Now, this is the big question mark. Now, in case of railways, now friends, if any party wants to institute a suit against the central government, especially against the Department of Railways, then he has to serve 2 months prior notice under section 80 subsection 1 of CPC. It is compulsory, friends. In case if he wants to institute the suit against the railways, he has to address such statutory notice to the general manager of that railway. Okay, the general manager, the general manager of that railway. For instance, South Central Railway, Southern Railway, Northern Railway, okay, Western Railway. Here, the general manager, South Central Railway. In case if a party wants to institute a suit against railway department of the central government, then he has to address such statutory notice to the general manager of a particular railway zone. Okay, now it is about railways. Otherwise than railways, in case of other departments, other central governments, other departments pertaining to the central government. Now, to whom the statutory notice under section 80 subsection 1 CPC has to be addressed. It is very clearly stated, friends. It is very clearly stated. In case of other departments, secretary to that ministry, secretary to that government. Okay, secretary to that government. For instance, if a party wants to institute a suit against the central government, especially relating to home department, then the secretary to the home department, secretary to external affairs, secretary to defense, secretary to tourism, secretary to information and broadcasting. Now, friends, if a party wants to institute a suit against a particular department of central government otherwise than railways, then such notice, the prior notice under section 80 subsection 1 CPC has to be addressed to the secretary to that particular government, to that particular ministry. It is very clearly stated under section 80 of CPC. Friends, if a party wants to institute a suit against the state government otherwise than Jammu and Kashmir, okay, now such suit has such prior notice under section 80 subsection 1 of CPC has to be served compulsorily on the secretary to the government, secretary to the government, or very important friends, or the district collector, the collectorate of the district, the collectorate of the district. It is very clearly stated. In majority of the cases, the district collector is shown as a party, okay, to the district collector. 2 months prior notice under section 80 subsection 1 CPC is generally served by the party who wants to institute a suit against the state government. It is very clear, friends. In case of Jammu and Kashmir, okay, in case of Jammu and Kashmir, the secretary to the government the chief secretary to the government, that is the only difference. In other states, secretary to the government. In case of Jammu and Kashmir, the chief secretary to the government, he has to institute a suit against the chief secretary to the government of Jammu and Kashmir. This is about section 80, friends. This is about section 80 subsection 1. And in case of public officer delivered to him or left at his office, stating the cause of action, the name and description and place of residence of the plaintiff, and the relief which he claims, and the plaint shall contain a statement that such notice has been so delivered or left. Okay, here if your party wants to institute a suit against the government for a suitable relief, in the averments of the plaint, he has to very clearly state that I have already given a statutory mandatory notice required under section 80 subsection 1 of CPC prior to 2 months prior to the appropriate the collector of the district, the collectorate of the district, the district collector, on so and so date the same is served. Okay, the relief I am claiming in the present plaint is also intimated to him. Therefore, section 80 subsection 1 notice is already given. Therefore, the honorable court may please to number the suit and pass and add interim injunction. Such kind of relief can be sought for by the party in case a statutory notice has been already addressed to the concerned parties, as we discussed just now. Okay, now friends, section 80 subsection 2, section 80 subsection 2, it is an exception to section 80 subsection 1. Friends, a suit to obtain an urgent immediate relief. Okay, urgent or immediate relief, these two words are used, friends. Urgent or immediate relief against the government in those circumstances, or any urgent or immediate relief against the public officer in his official capacity, then the party may institute such suit with the leave of the court. Therefore, with the leave of the court, with the permission of the court, then without serving a notice, a statutory notice under section 80 subsection 1 of CPC. Okay, then he can institute a suit. Then after satisfying with after hearing the parties, then this notice has to be served to the government or public officer, friends. Reasonable opportunity has to be given to the other party. Then after satisfaction of the court may pass the appropriate order. Okay. Okay, in case no such urgent or immediate relief has been pleaded to satisfy the honorable court, under those circumstances, the plaint may be returned by the court. Therefore, friends, Section 80, subsection 2 is dealing with an exception to Section 80, subsection 1. Therefore, friends, in majority of the cases, statutory notice under Section 80, subsection 1 is not generally served to the government by the parties, by the plaintiff, in case the government is the defendant, friends. Under those circumstances, along with the plaint, they also filed an application under Section 80, subsection 2, read with Section 151 of CPC, to dispense with statutory notice under Section 80, subsection 1. Okay, for the reasons stated in the accompanying affidavit, it is therefore prayed that the honorable court may please it to dispense with a statutory notice under Section 80, subsection 1 against the respondent defendant in the interest of justice and number the suit. This kind of prayer is generally used in case of any petitions filed along with the plaint, if they or if they are claiming some urgent or immediate relief against the government, friends. Therefore, such kind of petition under Section 80, subsection 2 is mandatory. Without filing of this petition, even the plaint cannot numbered, it can straight away returned to the plaintiff, friends. Therefore, this is the importance of Section 80, subsection 2. Okay, friends, do you have any doubts regarding this this section? Do you have any doubts regarding this section? That is Section 80, subsection 2. In case of urgent and immediate relief against the government, with the leave of the court, with the permission of the court. Therefore, with the permission means he has to file an interlocutory application, an IA. He has to file an interlocutory application under Section 80, subsection 2, praying the honorable court to dispense with Section 80, subsection 1, CPC notice. Okay, without serving a notice under Section 80, subsection 1 of CPC, if the plaintiff satisfies the court by showing the urgent and immediate reasons for institution of a suit, then under those circumstances, the court can dispense with such notice, and immediately the court can number the plaint, and the plaint can become a original suit, friends. OS number will be allotted to the plaint. This is the importance of Section 80, subsection 2. Therefore, Section 80, subsection 2 is an exception to Section 80, subsection 1, friends. Now, let us see the next one, the next important one, that is Section 80, subsection 3. It speaks that no suit instituted against the government or against the public officer in respect of any act purporting to be done by such public officer in his official capacity shall be dismissed merely by the reason of any error or defect in the notice. Therefore, if there is any error or any defect in the notice, then such suit shall not be dismissed. Therefore, no dismissal, friends, only return. Plaint shall be returned. No dismissal of the suit, even though there is a defect or there is an error in the notice, friends. No dismissal of suit, even though there is a defect or error in the notice, in the statutory notice required under Section 80, subsection 1 of CPC, friends. It is very clearly stated. if such, if no such notice, if such notice has been given to the government, but there is some defect or error in that notice, then it is not a ground for dismissal of a suit. Only the suit can be returned, friends. The name, description, and residence of the plaintiff had been so given as to enable to appropriate authority or the public officer to identify the person serving the notice, and such notice has been delivered or left at the office of the appropriate authority specified in subsection 1, and the cause of action and relief claimed by the plaintiff had been substantially indicated. Therefore, friends, generally the name of the person, Mr. ABC, son of XYZ, aged about 27 years, his religion and his occupation, thereafter his residential address has to be very clearly stated in the notice, friends, so as to the government can easily identify the plaintiff. Along with this one, the notice shall state about these things. Along with this one, the notice shall state about the cause of action, why he wants to institute a suit. Okay, therefore, this one, the notice shall state about the cause of action for institution of such suit, and friends, the relief claimed, therefore these have to be very clearly stated under section 80 subsection 1 statutory notice, friends. Even though there is a defect in mentioning all these for the cause of action or relief claims, then the court shall not, the court shall not, yes, the word shall is used, friends. The court shall not dismiss the suit on the ground that there is a defect or error in the notice served upon the government by the plaintiff under section 80 subsection 1 CPC. That is very clearly stated under section 80 of the act, friends. Now let us see few case laws with regard to this one. Now let us see few important case laws, friends. The first one is Pushkaraj versus state of Mizoram, state of Rajasthan. In this case, friends, in this case, it is held that while filing a suit against a public servant, giving notice under section 80 CPC shall be necessary only if the act or omission of such public servant was committed while acting in his official capacity. Where the public officer is not doing any act or omission under his official capacity, if he do any wrong, if he commit any tort, then it is his private act, friends. Therefore, statutory notice under section 80 subsection 1 of CPC is not mandatory. It is very clearly stated. That law itself very clearly stated about this thing, friends. Therefore, this is about section 80 of CPC. Thereafter, section 81, friends. Section 81 of CPC. Let us see the ingredients of section 81. Section 81. Section 81 of CPC is pertaining to exemption from arrest or personal appearance. Okay. Exemption from arrest, and personal appearance. Now, friends, section 81 of CPC is dealing exclusively with exemption from arrest and exemption from personal appearance. Here, a suit instituted against a public officer in respect of any act purporting to be done by him in his official capacity, the defendant shall not be liable to arrest, or his property shall be attached otherwise than in execution of a decree. Therefore, it is very clearly stated that, friends, no arrest before judgment, no attachment before judgment. Therefore, arrest before judgment and attachment before judgment, these two concepts are unknown to section 81 of CPC. Therefore, friends, if the plaintiff wants to institute a suit against a public officer under his official capacity, if the plaintiff has filed an interlocutory application for arrest of such a public officer before the judgment, then no such arrest order shall be passed by the honorable court, as under section 80 of CPC. As stipulated under section 81 of CPC, no arrest before judgment and no attachment before judgment, friends. Therefore, there is no arrest before judgment, and there is no attachment of the property of a public servant who is doing his duty in his official capacity for attachment of his property before the judgment, friends. Therefore, these two interim reliefs are not available to the private party if he wants to institute a suit against the government, especially against a public officer in his official capacity. Okay. Now, friends, the second one says that where the court is satisfied that the defendant cannot absent himself from his duty without detriment to public service, it shall not exempt him from appearing in person. Therefore, personal appearance can be ordered, but if the court is satisfied that the defendant cannot absent himself from his duty without a detriment from the public service, then it shall exempt him from appearing in person. Therefore, a public servant has been doing his public service, he has a lot of work, he has to clear, he has to serve the people every day, he has a lot of work. Therefore, these words are very specifically used. Okay, detriment to public service, detriment to public service. Therefore, the court, if satisfies that without detriment to the public service, it shall exempt a public officer from appearing before the court. This is about section 81 of CPC, friends. Now let us see section 82 of CPC. Okay, this is section 81. Now let us see section 82 of CPC. Execution of decree. Execution of decree or a decree. Friends, where a suit by or against the government or by or against the public officer in respect of any act purporting to be done by him in his official capacity, a decree is passed against the Union of India or the state, as the case may be, the public officer or the Union of India or the state or the public officer, then such decree shall not be executed except in accordance with the provisions of subsection 2. Therefore, subsection 2 of section 82 CPC very clearly states that execution shall not be issued in any such decree unless it remains unsatisfied for a period of 3 months computed from the date of such decree. Therefore, friends, from the date of decree, no immediate execution, no immediate execution. Then from the date of decree, there must be at least 3 months time, 3 months period, 3 months interval. Only after completion of 3 months from the date of decree, then execution proceedings can be initiated against the government. But friends, in case the defendant is a non-government, then immediately execution proceedings can be initiated. But if the defendant is the government, then only after pronouncement of a decree, after 3 months period of time, execution proceedings can be initiated for arrest or attachment or any other relief for delivery of possession, etc. and etc. Okay, this is about section 80 subsection 2, friends. Section 80 subsection 2. The provisions of subsection 1 and 2 of CPC, especially 82, section 82 of CPC, shall apply in relation to an order or award as they apply in relation to a decree if the decree or award is passed or made against the Union of India or state or a public officer in respect of any act as aforesaid, whether by the court or by any other authority. Therefore, if the arbitrator has been passed an award, even though after from the date of decree, 3 months period from the date of decree, then only an execution petition can be initiated as per the award of an arbitrator. Therefore, from the date of decree, no immediate execution. Only after 3 months period from the date of decree, or only after 3 months period from the date of award, then only execution proceedings can be initiated for arrest or for attachment or for delivery of possession or for any other proceedings under execution, friends. This is about section 82 of CPC. This is about section 82 of CPC, friends. Then this is about section 79 to 82, or exclusively dealing with these sections, or exclusively dealing with this one, suits by or against the government. It is very clear, friends. According to order, the next one, according to the principle, friends, according to this one, that is order 27, rule 5A, if any suit has been instituted against a public officer, then the government can implead as one of the defendants. Okay, it is very clearly stated. According to order 27, rule 7, where the defendant is a public servant, he should be given an additional time to make reference to the government. Therefore, additional time shall be given. Thus, these are the special provisions under the Code of Civil Procedure with regard to suits by the government and suits against the government. Friends, do you have any doubts regarding this subject? Friends, do you have any doubts? Friends, do you have any doubts regarding this subject? Okay. Friends, do you have any doubts regarding this subject? Friends, Unacademy Judiciary is the India's largest education platform, which has been conducting free special classes every day. These classes will be conducted by the top educators of the country. These are the free live classes. These are exclusively available on Unacademy Judiciary, friends. You can download an app, Unacademy Learners app. Okay, through this Learners application, you can continue. You can watch these videos. Okay, these free classes will cover Indian Contract Act, CPC, jurisprudence, Criminal Procedure Code, Constitutional Law, Hindu Law, Indian Penal Code, Indian Evidence Act, and all other local laws, friends. It is a great opportunity for everyone. Friends, the expert guidance for your Judiciary 2020 preparation has been given by Unacademy Judiciary. The top educators of Unacademy Judiciary have curated detailed batch courses to provide you with everything you need to crack your judiciary services examinations of your respective states. Friends, a batch has been commenced on 7th July, October 6th, 13th October, 27th October, 3rd November, 17th November, on 1st December. Recently, a new batch has been started. Friends, you can join in any of these batches. You can also use the code SUBHAN LIVE SUBHANLIVE in order to get 10% of offer in this subscription amount. Friends, you can also use the code SUBHANLIVE for 10% of offer. Apart from these live classes, Unacademy Judiciary Iconic, with the name of Unacademy Judiciary Iconic, now .live. Now live tutoring has been conducted. Live doubt solving sessions have been started. Friends, these are the personalized one-to-one doubt solving with the experts of Unacademy Judiciary. Friends, 1:1 live mentorship will be available in Unacademy Judiciary. Friends, get personalized expert guidance on exam strategy and get help whenever you stuck for the same. Friends, mains focus test series. Therefore, mains answer writing practice tests will be evaluated by the experts. Therefore, 1:1 live mentorship is available. Therefore, it is a personalized and one-to-one, one-on-one doubt solving. This is an excellent opportunity for every aspirant of judiciary. Friends, share your written answers of subjective and full-length test practice for evaluation by the subject matter experts. Therefore, you will get the personalized coaching from Unacademy Judiciary. Friends, these are the special features. These are the features of special classes conducted by Unacademy Judiciary through its platform, Unacademy Learners app. These are the live and interactive classes. Friends, you can attend the live classes. You can participate in the live chat. You can get your doubts cleared all during the live session. Friends, you can participate in the 4 polls for the learners. You can respond for the polls for better understanding of a particular topic. Friends, you can raise a hand. Even the plus subscribers can directly talk with the educators in the live class and they can get their doubts resolved in the real time. Friends, you will never miss any class. You will get notified for all the lessons, upcoming courses, and recommendations curated for you. Friends, you can download the lecture notes by way of PDF. Okay, you will get access to all recorded sessions. You will get access to all recorded sessions of live classes. You can revisit the important topics whenever needed for the same. Friends, if you have any electronic gadget, you can watch the live classes at any time from anywhere from your electronic gadget having internet connection like your PC, tablet, phone, or laptop. Friends, if you get the plus subscription, you will get all the access to Unacademy Judiciary services. You will get India's best educators. You will have interactive live classes. You can participate in the live test, and you can take the live test and you can participate in the quizzes. Friends, structured notes will be available. PDF notes can be downloaded if you get an Unacademy Judiciary subscription today. Why are you waiting for, friends? You can take the mock test on core subjects of judiciary. These are just started, friends. From Monday to Friday, in between 9 a.m. to 9:30 a.m., the mock test will be conducted by Unacademy Judiciary on core subjects of judiciary, especially on CPC, CRPC, CPC, and Evidence Act. On every Monday at 9 a.m., there will be a mock test, T20 mock test on IPC. On every Tuesday, there will be a mock test on CRPC. These are the timings, friends. Timings are common, 9 a.m. to 9:30 a.m. On every Wednesday, there will be a mock test on CPC. On every Thursday, there will be a mock test on Evidence Act. These are the timings, friends. On every Friday, there will be a mixed bag series. On every Saturday and Sunday at 7 p.m. to 8 p.m., there will be a detailed analysis of all the tests. Thus, this is about T20 mock test series on core subjects of judiciary by India's largest education platform, Unacademy Judiciary. Friends, this is the pricing plan for Plus subscription. 1 month plan, 3 months, 6 months, 12 months, 18 months, and 24 months plans are available. These are the prices for various plans. You can see the difference, friends. If you get the subscription for more months, you will be charged less amount of subscription fee, friends. Subscription fee, friends. You can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer in Plus subscription amount of Unacademy Judiciary. Friends, apart from this, Unacademy Judiciary has started Unacademy Judiciary YouTube channel, wherein my live classes are exclusively available on every Tuesday and every Thursday at 9 p.m. to 10 p.m. Okay, friends, don't miss it. These are the live classes. These are exclusively available on Unacademy Judiciary YouTube channel. Friends, apart from this, Unacademy Judiciary has also started Unacademy Telegram channel. Join Unacademy Telegram channel. Get updates regarding every upcoming class, every upcoming course. All the recommendations curated for you. Okay, friends, apart from this, my live classes, my Plus classes, and my free classes are also exclusively available on Unacademy Judiciary Learners application, and these classes are also available in Subhan's Legal World, my own YouTube platform. Friends, this is about today's class. As we know, we have discussed these important concepts today. Okay, suits by or against the government, section 78, 1879, sorry, section 79 to 82, or the sections. These are the relevant sections of law which are dealing with the concept of suits by the government and suits against the government. Friends, I think you understood this concept. Okay, stay tuned with Unacademy Judiciary. Thank you very much, friends. Subscribe Unacademy Judiciary channel. Stay tuned with Unacademy Judiciary. Thank you very much. Let us crack it.